The case Ortega-Melendres versus Arpaio is taking place in Arizona. It challenges the practices of one Sheriff Joe Arpaio of Maricopa County when it comes to racial profiling and the stopping of people he and his folks consider potential illegal immigrants. What's it got to do with the Supreme Court decision on Arizona's immigration law? And exactly what can be expected to come out of this legal challenge? Here to talk about that is Omar Jadwat. He is a senior staff attorney at one of the organizations bringing the case. That's the ACLU. Omar, thanks for coming in.
Thanks for having me.
So let's start with Melendres. Who is he?
Well, so just to give you an idea of what the case is about, Ortega-Melendres, the plaintiffs in that case that we represent at the ACLU, are a number of individuals who have been profiled for being Latino by the Maricopa County Sheriff's Office, Sheriff Joe's organization. And they represent a class of people similarly situated. So what we see is a pattern and practice of the Maricopa County Sheriff's Office stopping and arresting people on the basis of their race. And the reason they do that, or the thing that causes them to do that, is the belief that they can go after people that they think are illegal immigrants, and that the way to figure out who is an illegal immigrant is to look at how they look or how they sound, what kind of accent they have, which is, of course, a deep problem for the many Latino citizens and non-citizens who live in Maricopa County.
So there are a variety of plaintiffs in this class action suit. Tell me a story. What has one of them gone through?
For sure. So I can tell you about our plaintiffs, the Rodriguezes, who were out in a recreational area on a recreational vehicle, having fun together with other people from the area. They're U.S. citizens, and they were pulled over. Nobody else was pulled over. The police officer asked them for identification. David Rodriguez supplied his license and registration. And the officer said that wasn't good enough, that what he had to actually do was produce a social security card, other things that the officer thought would be sufficient to prove that he was an official U.S. resident. And the idea that U.S. citizens who obviously aren't required to carry even a license, I mean, if you're driving you are, but who aren't generally required to carry any kind of national identification, would be singled out on the basis of their race and required to produce more and more personal identification and information just to satisfy a police officer who has no business enforcing immigration law in the first place, is, the kind of thing that we're trying to focus on in this case and to make sure it doesn't happen again.
So what has all of this got to do with the Supreme Court decision involving 1070, Arizona's so-called papers, please law?
So what happened with the Supreme Court case on 1070 is that even though the court struck down most of the provisions of the law that were up in front of the Supreme Court, it said for now it wasn't going to strike down the fourth provision of the four, which was the show me your papers provision of the law, which would allow the kind of, allow police to layer a degree of immigration investigation on top of ordinary criminal stops, arrests, investigations. The court, I want to be clear, did not say that that provision was okay, but it said that on the record right now it wasn't prepared to strike the law down. And so there are ongoing challenges to SB 1070, and one of the key things that I think links these two is that we see that when they passed SB 1070, there was an explicit desire to protect and mandate statewide Sheriff Joe's practices in Maricopa County to try to make all of the police officers in Arizona act that way. And we knew, even when SB 1070 was passed, that what Sheriff Joe was doing when he did immigration enforcement was racially profiling people. So it's really, I mean, the key here, I think, is that we're demonstrating what we already knew, which was that Sheriff Joe engages in racial profiling by making him, by law, the model that all of the other Arizona enforcement entities would have to follow, that's really an attempt to mandate racial profiling across the state.
So your case in lots of ways, and there are various people bringing it, but the ACLU is our lead group involved, gets to the heart of this question of how are the laws being implemented. And it's not just 1070, it's also, it seems to me, the federal program 287G, under which the sheriff's deputies are deputized, in a sense, to work for the federal government on this immigration issue. Why has all the attention been on 1070 when 287G is still, it seems to me, kind of the heart of the problem?
Well, 287...
And just for the sake of our audience, remind people what 287G
So Section
does.
287G is a provision in the immigration laws that allows the federal government to basically deputize state or local officers as immigration agents for various purposes. And this is a program that for many years after it was first enacted, the federal government said, we don't want to do that. It's not a good idea. It's not what we need to be doing with our resources, is making these people into immigration agents. In the Bush administration, they started actually towards the end quite aggressively pursuing these 287G agreements with law enforcement agencies around the country. And those agreements have continued in effect, and there's actually been a few new ones in the Obama administration. 287G is also just one, is the most formal cooperation agreement, but there's also other programs that try to enlist state and local police in immigration enforcement. There's something called SCOM, or Secure Communities, and there's some other programs as well. And so, I think what we see is, you're right to perceive that there's some of the same problems with 287G and with SCOM that there are with SB 1070 and with the laws in Georgia and Alabama and these other places, that the basic mistake is making local police into immigration agents. And you have, because as police have told us repeatedly, you can't determine by looking at somebody whether or not they're what you call an illegal alien. That in general, there's not a way to systematically put these laws into effect without relying on people's skin color, ethnicity, the way they speak, all of these things that we really don't want police to be doing. And so, so I think that very much is part of the fight, but obviously the federal government isn't going to sue itself over 287G. That's an element that hasn't been as that there haven't been the same kind of court challenges to the same degree. But that is obviously an area of real concern.
If your case comes out the way that your plaintiffs want it to, what will it lead to? And will it lead to challenges of that kind of practice?
Well, so I think there's two cases here that we've been talking about here. There's the profiling case against Joe Arpaio, the Ortega case, and there's the SB 1070 challenge. And I think, they do kind of fit together in a certain way. I think the Arpaio case is really important in terms of demonstrating to people in a very visceral way with real stories told in court, witnesses testifying about the real costs, the real human costs across the state and across any place where you would try to do something like this, of, again, making police and immigration agents. That it's, the way that U.S. citizens, that lawful residents, their families suffer, the way that, policing gets twisted and distorted, the way that, in fact, if you see, we've had a chance to look through some of Sheriff Joe's files, and we see that one of the ways that he decided which neighborhoods to target for these immigration sweeps that he did was based on, patently racist emails that were coming in and letters that were coming in from people in the community saying, there are too many Mexicans in this neighborhood, you've really got to do a sweep. And so to see that, that's the kind of corruption, I think, of an agency that should be there to protect us all, I think it's really important to see, to have documented the kinds of problems that really do result from the sorts of policies that SB 1070 and the other state laws are trying to put into place.